Okay, let's start. Okay, can you see the screen?
Yeah, I am reading the book.
Yes, yes.
Yeah, de facto recognition, pay 10. Who wants to go? Nirmala madam, మీరు చదువుతారా మరి?
చదువుతాను కానీ వాయిస్ ఎక్కడ ఉంటే చెప్పండి. I don't want people to lose out. Okay?
Sure.
Okay, go ahead, start.
Yeah. So, de facto recognition. Recognition is formulated based upon the international law structure that relies on formal indication by one state that it acknowledges the existence or legitimacy of another state or legitimate government. So one state should be recognized by another state or legitimate government. This is called recognition. The act of recognition is a formal act with legal and political implications for international relations. So once the state is recognized, it has a lot of legal and political implications. So therefore, recognition is important. Recognition usually falls within two categories. De jure recognition, which is full legal permanent recognition indicating that the entity has been completely recognized with respect to its independence, sovereignty, or legitimacy in the international legal order. That is de jure recognition, meaning complete recognition, comprehensive recognition is given. The other one is de facto recognition, which is provisional and factual recognition, saying the entity has effectively jurisdiction and authority over territory and governance, but without recognition as legally operating over the territory or authority until it is recognized under the first category. So de facto recognition lo entante, which is provisional factual recognition, saying the entity has effective jurisdiction and authority over territory and governance, but without recognition as legally operating over the territory or authority. వేణుగారు ఇదేంటి ఒకసారి డిఫాక్టో చెప్పండి. అదే నెక్స్ట్ ఏంటి? I understood the first one, de jure. De facto is what? Should we read further and then?
As you read, you'll understand, madam. It's easier.
Okay,
I'll explain. No issues. Yeah.
Done. De facto recognition usually given in situations of political sensitivity or instability caused by conflict or some other variance like revolution, coup, or secession. The recognizing state will allow for somewhat functional relationship in the practical affairs with a political entity that is, by purely a practical fact, a government. The recognizing state will allow for somewhat functional relationship. Okay, a state aithe recognize chestundo, it will allow for little bit of relationship in a practical manner. The recognition granted is lower than intentions to formally recognize the entity as a legitimate government, because the recognizing state would prefer to engage with the factual authority of the entity without adopting, legitimizing, or recognizing the entity as being legitimate or having stability. Very, very complicated. I think we need to simplify this. De facto recognition does not grant the entity has received the full benefit of becoming a recognized state with the international legal personality or defined diplomatic ties. So this is what it is. De facto recognition lo full legal personality, international legal personality radu. Therefore, legal personality lenappudu diplomatic ties establish kavu. But other than that, within its territory, I think the country can operate. But as far as international relations, recognition is important. De jure recognition is mandatory. If I'm right or wrong, you correct me. Theoretical framework, declaratory versus constitutive theories. You guys are able to hear me?
Yes, ma'am. Yes.
Yeah. Declaratory versus constitutive theories. So the discussion of the definition of recognition and what effect it has is separated by two broad theories. So basically, what is recognition, how it's recognized is based on two broad theories. Theory. In public international law, the declaratory theory applies heavily as the prevailing position and view of recognition. recognition merely acknowledges the existence of a state or government already fulfill the
Ma'am, your voice is breaking.
objective criteria. Breaking,
Hello.
so I think I have some network issues especially here. Okay, can you read, Himali?
Yeah, okay, I'll read. I'll read. Just
Yeah,
one
yeah.
minute. Yeah, theoretical framework, declaratory versus constitutive theories. The discussion of the definition of recognition and what effect it has is separated by two broad theories. First is declaratory theory. In public international law, the declaratory theory applies heavily as the prevailing position in view of recognition. Recognition merely acknowledges the existence of a state or government that has already fulfilled the objective criteria for statehood. Thus, statehood is a factual reality existing apart from the recognition. The Montevideo Convention on the Rights and Duties of the States, 1933, which established the classical criteria for statehood, which includes a permanent population, a defined territory, a government, and capacity to enter into relations with the other states, substantially demonstrates and supports this theory. So the Montevideo Convention has given some criteria for statehood. They are permanent population, defined territory, government, and capacity to enter into relation with other states. And yeah, so all this demonstrate and support this theory, declaratory theory. The declaratory theory is the perspective that once a certain amount of factual criteria is met, an entity will become a state, and this can occur without the recognition from any other states. Okay. The constitutive theory contends that recognition from other states is necessary to create legal statehood. So, for constitutive theory, you need recognition from other states also. Without recognition, an entity will not have international legal personality and will not have any of the rights and duties owed to a state under international law. Ultimately, the concept of statehood under international law is mainly in favor of the declaratory theory. But state recognition is still an important concept in terms of practical and political consequences. Even if a state exists on paper, without widespread recognition, the state can be severely impeded from engaging in international relations, entering into treaties, or joining international organizations. So, mainly it is based on the declaratory theory, concept of statehood. So, we'll just read this table. De facto versus de jure recognition. In distinguishing between the two terms, there are effects which will flow from de facto and de jure recognition. So, feature is what is the nature? Nature of de facto is it is temporary, factual, and it is informal. De jure recognition feature nature is it's permanent. Permanent, it is legal, definitive. Okay, so that is de jure recognition. Legal consequences of de facto. Legal consequences are that it is limited. Okay, no diplomatic relations, treaties. So recognition is very extremely limited. De jure recognition means normal diplomatic relations, ability to enter into treaties, right to make international claims. So they are the so ability to enter into treaties, normal diplomatic relations are the legal consequences of de jure recognition of a state. Revocability is de facto recognition can be easily withdrawn. De jure recognition is hard to revoke, often requiring cessation of statehood. Okay. Use use cases. Use cases, revolutionary regimes, de facto control over intervened territories, interim governments is de facto recognition. De jure recognition is stable, established governments, full sovereign states. I didn't understand this, but okay, we'll last point I didn't get, but de facto and de jure is this is the basic distinguishing. These are basic distinguishing features. So the relevant case laws: Tinoco arbitration, Costa Rica versus Great Britain, 1923. Facts are after a revolutionary regime, that is the Tinoco regime. Uh, After a revolutionary regime was not recognized by the later legitimate Costa Rican government, The case considered whether the contracts created by the Tinoco regime would be binding. So the key point here is the arbitrator. The arbitrator, United States Chief Justice William Howard Taft, held that the refusal of Great Britain to formally recognize the Tinoco regime had no effect on the acts and obligations entered into by that government while it was in effective control of Costa Rica. This decision strongly supports the declaratory theory, stating that it is the effective exercise of control and factual government which is determinative of government's ability to bind the state internationally even without formal recognition. Strongly supports the declaratory theory that it is the effective exercise of control and factual government. Okay, so we'll go to the next one, that is Luther versus Sagor, UK 1921. So facts is the British company Luther sued Sagor, claiming ownership of timber that had been confiscated by the Soviet government, a government which UK had not formally recognized. The question being considered by the UK courts was the legality of the Soviet confiscation decree. Key point here is this case illustrates the constitutive theory of recognition. Constitutive theory of recognition is recognition from other states is necessary to create legal statehood. Okay, so this case illustrates the constitutive theory of recognition. The Court of Appeal ruled that the Soviet decree had no legal effect in UK because UK government had not recognized the Soviet government. But by the time the case was heard, the UK government had granted de facto recognition. The court then concluded that this de facto recognition was sufficient to allow for recognition of legal validity of Soviet decree in UK. This case demonstrates the profound legal implications of the recognition, even de facto recognition in domestic legal systems, uh, namely the ability to give effect to or deny effect to the acts of the foreign governments. So, what is the contemporary relevance here? Despite theoretical problems of recognition persisting, the issues are of continued relevance in the following matters. So, in Palestine, a number of UN member states have recognized Palestine as a state, sometimes de facto, reflecting their recognition of the goal of statehood through limited self governance. De jure recognition is debated and contested as its development is intertwined with continued conflict. So, contemporary relevance is Palestine is an example. Taiwan operates as a de facto independent jurisdiction with its own democratic government and real economy, but is only recognized by a limited number of states as a result of one China policy, uh, requiring states recognizing China to legally acknowledge that Beijing is the only legitimate government of China. This demonstrates how political considerations can inherently override fact-based states. So, example, Palestine, Taiwan, they both have de facto only. Mostly de facto. The Taliban, Afghanistan, since coming back to power in 2021, Taliban has de facto authority to govern Afghanistan. However, substantial de jure recognition from international community would mean, broadly speaking, recognition of the legitimacy of the Taliban government, which is not forthcoming to date in part due to human rights, especially women's rights, and the nature of which Taliban govern, demonstrating political conditionalities that can come with recognition. So, the above examples illustrate an important point about the importance of political, strategic, human rights considerations in awarding and withholding of recognition, and further exemplifies how politically laden recognition blurs the distinctions between declaratory and constitutive theories as a matter of practice. So it's all theories, but in matter of practice, it can be taken differently. So conclusion here is de facto recognition for the purpose of international law provides an effective and flexible mechanism to utilize in relation to recognition considering in circumstances. So just In an increasingly complex world, recognition remains a powerful mechanism that seeks to temper and weigh the factual realities of control against legal principles and political concerns into global legal order. Okay. Sir, you want to explain? Want to add anything?
Okay,
Explain.
fine. Sure, Himali. Uh, Basically, I think what we have to remember is in the long question, I think Pavan and myself have made with that video where we were talking about de facto and de jure. So basically, de facto is basically a temporary kind of a situation where revolutionary or army, military junta takes over. సో అప్పుడు టేక్ ఓవర్ చేసినప్పుడు మిమ్మల్ని ఇప్పుడు జనాల్ని మేము రికగ్నైజ్ చేయము అనలేం కదా. It's not correct on other countries to say, okay, because your leader is bad, we will not recognize you, or somebody who's ruling you. So they will still have some rights, maybe because of the guy who is ruling, who has not done it in a democratic process or in a authoritative process లో చేసినప్పుడు or declarative process లో చేసి డిక్లేర్ చేసేసుకున్నాడు నేనే ఈ కంట్రీకి రాజు అని. Because at some point it might fall, right, and then it will come back to democratic institution, and then maybe it will become de jure. So basically de jure ante simple thing ante de jure jurisdiction undi. That means that de jure is the original. De jure ante మనకి యాక్చువల్గా where all of the countries recognize and they're legally entitled to rule. So they can have diplomatic channels, they can do lot of things outside the వేరే countries లో diplomatic ఇవి పెట్టుకోవచ్చు, చాలా చేయొచ్చు అనమాట. Whereas de facto is the person who is in actual control at that point of time. Okay, so he might lack legality or recognition, like Afghanistan or like you were reading, right? Taiwan is another example. So they are actually in control, but they might not have the legality or recognition. Okay.
Okay.
So, see, basically, yesterday also I was telling the way we have written the answers is basically we give an introduction or a description of what the topic is, and then we get into the legality of legal దీంట్లో where are these sections or where are these actually in where are these definitions actually in which acts. అది మనం రాస్తాం అనమాట. సో బేసికలీ దిస్ ఈస్ బేసికలీ a theoretical framework where it is declarative versus constitutive theory. సో డిక్లరేటివ్ అంటే బేసికలీ లైక్ ఇందాక చెప్తున్నారు కదా, లైక్ డిక్లరేటివ్ ఈజ్ బేసికలీ లైక్ ఐ జస్ట్ కమ్ and see this territory and say, and I declare myself as a king. Constitution theory is more of following a legal process of making a state, and then it becomes an international personality, and then it has a similar whatever equal rights as another state. So basically, broadly, these are the two theories from which de jure and de facto things have come. So అంటే ఈ రోజు ఫ్యాక్ట్ de facto and today's fact is you are the king, so that is temporary and that is the actual fact as of today. De jure is basically jury, permanent and legal. So de jure, de facto limited, de jure in normal diplomatic relations, ability to enter treaties, right to make international claims. Revocability and easily withdrawn, hard to revoke. De jure is hard to revoke. And revolution, example, stable establishment government. So last two cases, quicker we'll go through it. Cases, first case in Tenaco arbitration, Costa Rica versus Great Britain. In this, what happened is Costa Rica was ruled by Tenaco regime for a temporary time. So when the government came back, they said that whatever agreements Tenaco has done or his regime has done, we are not accepting. సో ఇది పెద్ద ఇష్యూ అయిపోయింది. Then the United Nations, sorry, the arbiter at that time they had an arbiter because it was in 1923. The arbiter, United States Chief Justice William, etc., had a refusal of Great Britain to formally recognize the Tenaco region had no effect on the acts and obligations entered into it by the government while it's still effective. The decision strongly supports the declarative stage, saying that effective exercise of the control. Basically, what they're saying is, మేము వాళ్ళ రికగ్నైజ్ చేయము అంటానికి లేదు, because they were actually a de facto government. Okay.
Okay.
So de facto, they were actually in the control in a factual government. So which also binds.
Temporarily.
So de facto ఉన్న some వాళ్ళు చేసే యాక్షన్స్ దే మైట్ బైండ్ ద స్టేట్ ఇంటర్నేషనల్. ఓకే, ఈవెన్ వితౌట్ ఫార్మల్ రికగ్నిషన్ అని వాళ్ళు జడ్జ్మెంట్
Okay.
ఇచ్చారనమాట. సో ఇప్పుడు అక్కడ ఏ గవర్నమెంట్ ఉన్నా వాళ్ళు చేసిన వాట్ ఎవర్, వాళ్ళు డిఫాక్టో కానివ్వండి, డిజ్యూర్ కానివ్వండి, వాళ్ళు చేసిన అగ్రిమెంట్స్ అయితే మీరు ఆనర్ చేయాలి. యాజ్ అ కంట్రీ యూ హ్యావ్ టు ఆనర్. ద
Okay.
సెకండ్ కేస్ ఏంటంటే లూథర్ వర్సెస్ సాగోర్. ఇందులో ఏంటంటే దిస్ వాజ్ అన్ ఇంట్రెస్టింగ్ కేస్ వేర్ there was a timber company which was basically owned by Luthor in Soviet. సో సోవియట్ గవర్నమెంట్ ఏంటంటే నేషనలైజ్ చేసేసి, కమ్యూనిజం కాబట్టి నేషనలైజ్ చేసేసి వాడిది లాగేసుకున్నారు. వాడిది లాగేసుకుని మళ్ళీ బ్రిటన్ కంపెనీ సాగోర్కే అమ్మారు. సో వాడు ఏం చేశాడు, యూకే కోర్టులోకి వెళ్ళి సాగోర్ మీద కేసు వేసాడు. అసలు సిన్స్ బ్రిటన్ డజంట్ రికగ్నైజ్ సోవియట్ యూనియన్ at that point of time, so the sale of my company is illegal in Russia
Okay.
అని వాడు కేసు వేసాడు అనమాట. బట్ ద గవర్నమెంట్ సెడ్ ఈవెన్ దో the British did not recognize the Soviet Union at that point of time, which is 1921. They actually recognized it as a de facto recognition ఇచ్చారు ఆ టైంలో. సో వీళ్ళు
Okay.
అమ్మినప్పుడు de facto recognition ఇచ్చారు కాబట్టి దట్ సేల్ ఈజ్ వ్యాలిడ్ అని చెప్పారు అనమాట. సాగోర్ కమ్మటం అనేది వ్యాలిడ్ అనమాట. ఓకే.
Okay.
Let's move on now.
Ma'am, any questions?
No, let's move on.
Okay, let's move on.
Pretty
Yeah.
elaborate, actually. Yeah.
Okay, so let's go to the 11th one. Who wants?
I'll read it. Problem. Shall I continue?
Yeah, move on. You have to do it very
Okay.
fast. Time లేదు ఎగ్జామ్స్ కి మనకి.
ఇంకా డేట్స్ రాలేదు కదా సార్, పర్వాలేదులే.
Okay, go ahead.
Fine, I'll do it, but still I'll do it fast. Formation of treaties. Treaties, formation of treaties, law making treaties. 3 times it has been repeated. Introduction. Treaties are the principal source of international law, as treaties are legally binding agreements established between subjects of international law, such as sovereign state and international organizations. Treaties represent a formal legal process with various rules, customary behavior, and conventions to rigidly regulate their creation, which result in instruments that create, alter, and terminate international rights and obligations between the parties to the treaty. It is the principal source of international law. They are legally binding agreements. Okay, so established between the subjects of international law, such as sovereign state and international organizations. Okay, law making treaty is a special type of treaty and is significant because they do not simply provide for bilateral commitments, they seek to formulate rules that generally apply to a wide range of states and may even be the default of customary international law itself. Law making treaty. Okay. Legal framework is Vienna Convention on Law of Treaties, 1969. Vienna Convention, this VCLT of 1969, is the primary legal instrument that establishes the formal legal framework to codify the customary international rules for treaty creation, validity, interpretation, and termination. So, key VCLT provisions that relate to treaty formation. Treaty formation key provisions. Into the Article 2, 21A provides a definition of treaty. డెఫినిషన్ ఏంటంటే ఇంటర్నేషనల్ అగ్రిమెంట్ కన్క్లూడెడ్ బిట్వీన్ ద స్టేట్స్ ఇన్ రిటర్న్ ఫార్మ్ అండ్ గవర్న్డ్ బై ఇంటర్నేషనల్ లా. International agreement concluded between the states in written form and governed by international law. And it is expressly limited to written agreement between the states. But treaties can exist under customary law in other formats. But mostly it is a written agreement. Article 6 provides that every state has the capacity to conclude treaties as an element of their inherent sovereignty. 7 and 8 outline who is authorized to represent a particular state to express the consent of that state to be bound by the treaty. That is, the head of the state, first is head of the state, second head of the government, third is minister for foreign affairs, or other persons expressly provided with full powers. So the common form of abbreviated power is a universal one. So these are the people who is express the consent to, okay, was bound by the treaty. Fine. Article 11 to 15 lay out various ways that bound by consent to be bound can be expressed, including by signature, exchange of instruments, ratification, acceptance, approval, or accession. Ratification is a common occurrence in significant treaties. The ratification enables states time to secure domestic approval, while accessions refer to situations that a state accedes to an already ratified treaty. Uh, so that is ratification and accession. 26 article codified pacta sunt servanda, agreements must be kept. Every treaty in force is binding on the parties to it and must be carried out in good faith. So that bona fide part. Stages of the treaty creation. Treaty making process. So till now we read about the legal framework, articles, all of them present in VCLT 1969. Next is stages of treaty creation. Treaty making process has traditional distinct stages: negotiation, adoption of text, authentication stage, consent to be bound, entry into force, and registration. So, first is negotiation. So, the states discuss, they draft the treaty terms, typically via the diplomatic channels or some meetings, international meetings. And all. So, first is negotiation. Second is adoption of text. The text is formally adopted when the negotiations conclude, generally by consensus or a two-third vote in multilateral conferences. Is given in Article 9 of VCLT. Authentication stage. This step confirms the final and definitive text of the treaty. Authentication stage is the final, okay, and definitive text, usually in the form of signature ad referendum or by initialing by the representatives. Consent to be bound. Here, the states express their definitive consent, usually by way of ratification. Formal act post signature requires domestic approval, uh, acceptance, approval, or accession. So, yeah. Then the next one, okay, this is consent. Basically, entry into forces. This is when a treaty enters into force when legally binding, which will be in accordance with its own provisions, usually when a certain number of ratifications occur or on a fixed date. So, negotiate the last is registration. So, Article 102 of the UN Charter states that treaties must be registered. They must be registered with the UN Secretariat to be invoked before any UN organ, including the ICJ. So, last is registration of the treaty. So, these are the stages of treaty creation. Next
I
is
believe
law
this was
making
the
treaties.
question in internal exam also, right? Ma'am?
This one, no?
Yeah,
Oh,
stages
yeah,
of.
no. Yes, stages of treaty. Yes, it was there. Okay, so law-making treaties, unlike contractual treaties, example bilateral trade agreement that creates specific reciprocal obligations for a few parties. Law-making treaties, also called multilateral conventions or normative treaties, seek to bring about general rules of international law on behalf of many states, establishing what rules will be considered customary international law. Some of the examples of law-making treaties are UNCLOS, which governs the maritime zones, maritime freedoms around the world. Rome Statute ante establishes ICC, defines international crimes. Paris Agreement ante climate change with universal participation. Geneva Convention is all humanitarian related, sets out humanitarian law and armed conflict. And law making treaties often codify the rules of customary international law that exist prior to the treaty adoption or create new rules of customary international law and therefore create binding obligations on non parties as well. So they codify the rules of nothing is there. Basically, they just codify the rules of this customary international law. If there is no rule, they'll create the new rules and they'll make it binding on other parties also, other non parties to the treaty. Relevant case laws is Qatar versus Bahrain, jurisdiction and admissibility ICJ 1994. Facts is the ICJ was asked to determine whether a number of letters and minutes of discussions exchanged between Qatar and Bahrain amount to a legally binding international agreement that give rise to the ICJ's jurisdiction in the dispute. An important point here is the court held that the form of an instrument the form of an instrument is not determinative of whether it is a treaty. The more relevant consideration is whether the parties had the intention, whether the parties had the intention to create a binding agreement. So this is the point here. Doesn't matter whether what the form is, but there must be an intention to create a binding agreement. Although informal in nature, the court held that contents of the exchanged letters and the context of exchanges made clear that the parties intended to create binding obligations and therefore an agreement, which amounted to a valid international agreement. This confirms that international law values substance over form in the formation of treaties. Qatar versus Bahrain. Okay. Nuclear test case Australia versus France. ICJ 1974. Australia and New Zealand made efforts to stop uh, France's atmospheric nuclear tests in the Pacific. France made multiple unilateral public declarations by its president and ministers, indicating an intention to cease atmospheric nuclear testing on a certain date. Key point here is the ICJ found that France's unilateral declarations were binding legal obligations under international law because France did a proper public statement accompanied by a clear intention to accept the obligations. The declarations alone created an obligation on the part of France similar to a treaty without any acceptance of obligation or reciprocal obligations by other states. This case demonstrates that legally binding obligations may arise irrespective of putting something down in writing and following the formal treaty making process if a state manifests a clear intention to create the obligations. So, made public multiple unilateral. Okay. Importance is treaties are vital to global governance. Mm, This their creation demonstrates the flexibility, not just formal conventions, but also less formal instruments like MOUs and joint declarations. MOUs, memoranda of understanding, and joint declarations can manifest legal obligations. Treaties are very often used to codify customary law or promote the establishment of new customary law, either old customary law ni codify jeda or creating a new customary law. So mostly they are used for that, made for that. Furthermore, treaties are increasingly including non-state actors as a party or indirectly. Example, the use of international organizations as a party. Treaties are also the legal basis for international cooperation for everything from addressing climate change to facilitating global trade, disarmament, or humanitarian law. So, very diverse topics: climate change, trade, global trade, disarmament, humanitarian law. All these treaties are used. So, they're vital to global governance. Conclusion is treaty making process is very formal, though it's flexible though flexible mechanism that is integral to developing and implementing international obligations. And treaties also embody the principle of consent of states and importance of good faith. As the ruling in Qatar versus Bahrain made clear, uh, and the nuclear test case demonstrates legally binding commitments may be created from unconventional state acts or are international unilateral acts, provided the requisite intention to create legally binding legal obligation exists. So today, lawmaking treaties are an essential mode of exercising international cooperation, maintaining peace, providing good governance on a global level. So this we can write. It's quite general. Continually adapting. Blah blah blah. Okay. Okay. Anything anybody wants to add?
Pretty straightforward, na? Let's move on.
Yeah, we'll move forward. Okay. So I'll read customs. Customs introduction. Customary international law is one of the initial and oldest sources of international law. Customary international law is made up of rules based on consistent practice of states. So custom is nothing but consistent practice of practice. So consistent practice of states which has been engaged in with a sense of legal obligation. So yeah. So unlike treaties which bind only the parties to the treaties, customary international law means to be generally binding on all states. Okay. So which represent a base level of universally accepted behavior. Customary international law develops organically from the actual actions of the states in the international sphere, which are unregulated when no codified agreement regulates them or have been ratified in a codified agreement. Uh, okay, fine. Also, customary norms have often been relied upon to form the development of principles as fundamental to international law, such as just cogence and erga omnes obligans. Okay, just cogence is peremptory norms, and erga omnes is obligations incurred to the international community as a whole, which we read in the previous questions. So, legal recognition and elements of a custom. The formal legal recognition of a custom as a source of international law is found in the Statute of ICJ, which article is 38(1)(b). Okay, so the court whose functions to decide in accordance with international law has regards to international custom as evidence of a general practice accepted by law. This article shows that customary international law has two distinct elements. First is state practice. Second is opinio juris sive necessitatis. Opinio juris and state practice. So state practice is the objective element. The practice has to be, so we are talking about custom, no? So state practice has to be widespread, consistent, uniform. So these are the features. That is, the practice has to be like that. So it can exist in several forms also, including a general custom, regional custom, then instant custom, it seems. Controversy exists. Okay, general custom is it is applicable universally. For example, prohibition on use of force, diplomatic immunity. All this is general custom. Regional custom means binding upon a limited group of states in a specific geographical area based on consistent localized practice between the members. Example, historical practice of granting asylum in Latin America. Oh, historical practice of granting asylum in Latin America. So that is a regional custom. Instant custom controversy exists is traveling and contentious hard notion of custom, which would suggest custom can rapidly ignite or evolve over a brief and immediate period based on immediate circumstances. Often, practice widespread positives. Example: certain norms concerning the law on outer space after Sputnik. So this is the state practice ante widespread, consistent, uniform. దాంట్లో general, regional and instant. General ante applicable universally, regional ante only to a limited group of states who have had a historical practice or localized practice. Opinio juris is this is I didn't understand this instant custom. Opinio juris is this is the subjective or psychological element. Uh, it refers to the belief by the states that the practice is obligatory. It refers to the belief. States themselves believe that this practice is obligatory or rendered necessary by the rule of law. It distinguishes the legally binding custom from mere courtesy, habit, or political expediency. Proof of opinio juris. Proof of opinio juris can be found in various state actions, including official statements, diplomatic correspondence, resolution of international organization, national legislations, judicial decisions, and provisions of the treaties. So this is the psychological element. It is the belief of the states that that practice is obligatory. So that proof can be found in state actions, official statements, all that. Okay. Resolutions of international organizations. So these are the two elements of custom. Okay, two distinct elements of custom. Interplay with other sources is customary international law plays well with other sources, particularly treaties, codification, crystallization, custom beyond treaties, bridging the gaps. A number of treaty provisions codify the existing uh, customary international rules so that rules are written down and more precise. Crystallization, the treaty may crystallize an emerging customary law that state practice and opinion juris are still developing. Custom beyond the treaties. Treaties may also give rise to customary law if a number of non-parties, okay, number of non-parties they adopt some practice, all or even part of treaty provisions out of the sense of legal obligations. But in some instances, in a different manner, customary law may be considered as dominant foundational custom. Okay, bridging the gaps. Customary law will also fill cumulative regulatory gaps where treaty law does not govern or is silent. Okay, what are the relevant case losses? North Sea continental shelf case, Germany versus Denmark, Germany versus Netherlands. ICJ 1969. Facts of this cases. In this case, the ICJ had to determine if a principle of equidistance related to delimitation of the continental shelf that was included in 1958 Geneva Convention had become a rule of customary international law binding on Germany. Point of interest is the ICJ established the hard and fast two-element test required for the customary law. Two-element test is what this opinio juris and state practice. Okay. ICJ established the hard and fast two-element test required for customary uh, law, that is consistent rate practice and opinion juris. The ICJ found that some state practice to support the principle. The court highlighted that simply being part of a treaty or sporadic practice is not enough. This practice must be extensive, virtually uniform, and done in a way that indicates that there is general recognition that a rule of law or legal obligation is involved. North Sea continental shelf case. Second is asylum case Colombia. I think we read this. Colombia versus Peru. Colombia argued that regional custom existed. Did we read this? I don't remember where we read this. Colombia argued that regional custom existed in Latin America, allowing it to grant diplomatic. Yes, we read this. Allowing it to grant a diplomatic asylum to a Peruvian rebel and unilaterally define the nature of the offense. The main point is ICJ rejected this claim by Colombia. The court wrote that a party invoking a regional custom must prove that this custom is established in such a way that it has become binding on the other party. Court found that there was lack of consistent and uniform usage by the relevant states, stating that practice described by Colombia was a result of political expediency and not a recognized legal duty, meaning they failed to meet the threshold for regional custom. Contemporary issues and applications is customary international law continues to develop. It defines fundamental prohibitions such as genocide, torture, slavery, aggression. It defines sovereignty and immune state immunity. It defines state responsibility. It matters in newer spheres such as cyberspace, where an area still developing treaty law. Of course, establishing opinion juris remains difficult, not least of which is established legally motivated act from political acts. However, the expanding identity of the states and expanding numbers of non-state actors present continuing issues for the traditional state-centric model of customary law and development. So basically, it is used for all this cyberspace newly developing area of international law. However, expanding identity of states and expanding number of non-state. Okay. Conclusion is remains important growing category of international legal system, and as established by the ICJ in North Sea continental shelf, asylum case and others, custom is established through the objective state behavior. This thing is important. Objective state behavior and subjective belief of legal obligation. Opinio juris. It is an evolving and continually stabilizing recognition of collective legal conscience of the international community. Okay. So, anybody wants to add? Sir, you want to tell the cases or anything? Don't see
Yeah, yeah. So one thing you have to
whatever.
remember in this is I'll make it very quick, Nirmala ma'am. Uh, Customary law is nothing but practice plus belief of legal duty. Without both, there is no binding rule. Okay. సో దేన్నైనా కస్టమరీ లా అనాలి అంటే అది ప్రాక్టీస్ చేయాలి అండ్ దే హ్యాస్ టు బిలీఫ్ ఆఫ్ ద లీగల్ డ్యూటీ సో విచ్ ఇస్ నథింగ్ బట్ స్టేట్ ప్రాక్టీస్ అండ్ ఒపైనో జ్యూరిస్ okay state practice is nothing but the rule that must be widely and consistently followed. Opina juris is nothing but states uh, must follow it because they believe it is a legal obligation, not because it is convenient. ఇది గుర్తుంచుకోండి. Okay. The other things is basically the cases are the same. Basically, I think continental shelf gurinchi two countries were fighting, Germany and Denmark, who are neighbors. So basically, what happened is when they were fighting, one suggested a principle, another suggested another principle. ICJ used the two element test, which is nothing but is it a consistent practice and is it an opina juris. So ఈ రెండు అయితే then Denmark will win the case kind of thing. So that's what it is. And the other one is asylum case. So asylum లో కూడా ఇది మా కష్టము మేము asylum ఇస్తాము అని చెప్పారు. సో అందులో కూడా టూ టెస్ట్ వాడారు అనమాట. బేసికలీ స్టేట్ ప్రాక్టీస్ పైన జ్యూరీస్ అంటే స్టేట్ ఈజ్ ఇట్ ఎ ప్రాక్టీస్ అండ్ ఇట్ ఈస్ ఎ బిలీఫ్ ఆఫ్ లీగల్ డ్యూటీ దట్ ఈస్ ద రూల్ మస్ట్ బి వైడ్లీ కన్సిస్టెంట్లీ ఫాలోడ్. పైన జ్యూరీస్ అంటే స్టేట్స్ మస్ట్ ఫాలో బికాస్ దే బిలీవ్ ఇట్ ఈస్ ఎ లీగల్ ఆబ్లిగేషన్. ఈ రెండు వ్యాలిడ్ అయితే చేయొచ్చు. ఇన్ దిస్ కేస్ ద కోర్ట్ సెడ్ ఇట్ ఈస్ నాట్ వ్యాలిడ్. సో ఇట్ ఈస్ నాట్ ఎ కస్టమరీ దిస్ థింగ్ ఫర్ యువర్ కంట్రీ అని చెప్పేసారు. ఓకే, rest I think you guys can go through the state practice of energies. We explained it. Can go to the next one. Okay.
Yes, please go to the next one now. Emily, there?
Yes. I'll read it. Okay. 1 minute. Sources of international law, 2 times repeated. I think this is there in long questions. Okay. Sources of international law, introduction.
Yeah, it's pretty straightforward.
Sources of international law are the formal processes and evidence basis supporting the creation, recognition, and binding force of rules of conduct governing relations between the states and other international actors. The sources of international law are of indeterminate international legal order and structure. The source of international legal order can be easily identified as having been authoritatively stated in a single statutory provision, Article 38, Clause 1 of the Statute of International Court of Justice, which is now widely recognized for its complete reflection of the sources of international law. So, Article 38, Clause 1 of the Statute of International Justice. This is recognized for complete reflection of the sources of international law. Primary sources under this 38, Clause 1. So, first is there are 3 primary sources. First is international conventions, which is treaties, again, international customs. And third is general principles of law recognized by civilized nations. First is international conventions, treaties. These are formal express agreements between either the states or international organizations creating binding legal obligations on the parties. Treaty can be bilateral, multilateral, or universal. Bilateral means two parties, multilateral multiple parties. Universal as in as much as two or more players but is seeking to become near universal in the future, such as the UN Charter. Treaties impose binding obligations based on the principle of pacta sunt servanda, that is, agreement must be kept. Treaties are based on principle of good faith. Okay, and treaty means explicit consent, declaration of will of a state to be bound. Second is international custom. We read this already. Customary international law is derived from consistent and general state practice, that is the objective element, and then the opinio juris, which is the subjective element. That belief, subjective belief that one is obligated by law to practice. Unlike treaties, customs bind all the states, even those states which are not involved in the makeup of the custom, unless the state has been a persistent objector from the outset, which is crucial to have universally binding principles like many just cogence principles, all that. Okay, that genocide, war crimes, blah blah blah. All that. Third is general principles of law recognized by the civilized nations. 38 1C. First is 1A, 1B, and 1C. Okay. So treaties, 1A, 1B is international custom, 1C is general principles of law recognized by the civilized nations. So these are those fundamental legal maxims or principles common to the principal legal systems of the world. Example, good faith, estoppel, res judicata, impartiality of judges, principle of unjust enrichment. Uh, so these are the common principles, y- which are principles that are common to most of the legal systems of the world. So they can fill the gaps where there is no treaty, no custom. So that time these general principles of law will take over. Okay. Next is subsidiary sources 38 1D. What are the subsidiary sources? Judicial decisions. Judicial decisions of the authorized courts like ICJ, Permanent Court of International Justice, then International Tribunal for Law of the Seas, or Arbitral Tribunal are as persuasive, and the absence of a strict doctrine of binding precedents in international law, that is stare decisis, is important to note. This would mean a rigid and literal approach to decide a matter. So these judicial. Okay, for next is judicial decisions. That is 38 1D law, subsidiary sources, judicial decisions, and teachings of most highly qualified publicists. All those scholars and law scholars, leading jurists, writings of all of them. So that all this that contribute to understanding, interpretation, systematic development of the international law. Okay, they do not make the law, but they only contribute to the understanding of the law, international law. Other modern sources are resolutions of international organizations, whatever resolutions of the UNGA. Okay, and yeah, they can serve as proof of state practice or opinio juris. Security Council resolutions, General Assembly resolutions. Uh, yeah, all this. So here they have written a point: Security Council resolutions under Chapter 7 of UN Charter are binding on UN member states. This is important. Security Council resolutions are binding. Next is unilateral declarations. A state can create binding obligations by issuing a public declarations. We saw that in that the France case, no nuclear test case. So unilaterally declared, public declaration. Next is soft law instruments, non-binding guidelines, declarations, or code of conduct. Example: Universal Declaration of Human Rights do not impose legal obligations on their surname, but they can impact the state conduct, shape state expectations, and often serve as a precursor to later hard law, that is the treaties or customs. So these are the other modern sources. Relevant case laws are North Sea continental shelf, then Nicaragua versus United States. So in North Sea, what is given is ICJ clearly articulates twofold test. We already saw this. Court determined that the treaty law using the equidistance method does not automatically incorporate customary international law but requires widespread and virtually uniform state practice as accomplished out of sense of legal obligation, not merely convenience. So there should be some form of uniformity in state practice and widespread use and all that. So all that was given by the court. And Nicaragua versus United States, the ICJ reaffirmed that customary international law is separate from treaty law. The court held that held the US legally held that US having withdrawn from the Treaty of Nicaragua enforced based on withdrawn from the treaty with Nicaragua enforced based on the customary norms. This case illustrates both that international law has many applicable sources and sources are independently binding. So a state cannot escape a legal obligations by simply relying on the treaty. Yes, it escapes the legal obligations. No, this US. I think something I remember. Conclusion: the sources of the international law provide a cohesive and flexible framework for generating and enforcing legal obligations on a multitude of factors and issues. In an ever evolving world, our multi layered sourcing system is flexible, providing a balance of formalism and practicality to foster justice, order, and cooperation among the states. So, sources are these. All the primary sources. Basically, you have to write the statute of International Court of Justice 38(1), then 1A, 1B, 1C, 1D. 1A law treaties, customary international law, 1C is general principles. In Endo Lakpote, general principles you have to follow. Subsidiaries, judicial decisions, and teachings of the scholars, jurists, and relevant case laws, and conclusion. Other modern Security Council resolution, UNGA resolutions. Yeah, that's it. Sir, you want to add, ma'am, anything?
Pretty straightforward. I think we should move to asylum.
Okay. Minute. Okay, I'll read asylum also. After this, if anybody wants to take up. Okay, I'll read asylum. Wait. Asylum is repeated 2 times. Asylum under international law refers to a right granted by a state to individuals fleeing persecution from another state. So basically, it is a right. Asylum is a right granted by a state to the individuals fleeing persecution from another state. It is usually based on political opinion, race, religion, nationality, or membership of a particular social group. Fundamentally, asylum is a sovereign right of the state's ability. It's a sovereign right of, of that state's ability to provide and an important humanitarian principle of the broader protection of human rights and dignity. While asylum is generally articulated as a right of the state, not under obligation to provide it, under the rules of general international law, the principle of non-refoulement, that is, not being returned to persecution, forms the only binding exception under the rules enforced by the refugee law. While asylum is generally articulated as a right of the state, not under obligation to provide it under the rules of general international law, the principle of non-refoulement forms the only binding exception under the rules enforced by the refugee law. Non-refoulement means not being returned to persecution. Okay, so basically a right granted by state to the individuals fleeing persecution from another state. Asylum subtypes. So there are 3 different forms of asylum. One is territorial asylum, then is diplomatic asylum. Diplomatic asylum. Is there anything else? Then there is political asylum. Territorial asylum means the most mainstream and accepted form of asylum is territorial asylum. The protection is provided when a person seeks and is granted protection within the territory of the state. So the person seeks protection and is granted also protection within the territory of the state where the person is physically present. Where the person is physically present. Okay. Territorial asylum adheres to the sovereignty of the state over its own territory, one that is most capsulated under the International Refugee Law, 1951 Refugee Convention, and the 1967 Protocol defines the term refugee as someone with a well founded fear of persecution. as a person with a well-founded fear of persecution as a refugee, and is delineated the obligations of the states. Most importantly, non-refoulement means not being returned to persecution. Okay. Once an individual is granted asylum, that person will normally be permitted to stay and often to work in the state that has granted them asylum. So that is territorial asylum. Second is diplomatic asylum. This is a controversial form of asylum granted while a person resides inside the diplomatic premises, that is, embassies, consulates, warships of one state that is within the territory of another state. There is no international universal acceptance of diplomatic asylum as a customary right under international law. It is mainly practiced in regional systems and bilateral agreements, mostly within Latin America, as the Caracas Convention on Diplomatic Asylum exists. So this is mostly person resides in the diplomatic premises. He belongs to one state, but he's residing in the diplomatic premises of another state. So that is what it means, and mostly it's followed in Latin America based on the Caracas Convention. Diplomatic asylum implicitly contradicts the territorial sovereignty of the host state and is essentially claiming jurisdiction within the territoriality of the host state. I didn't understand this line. Okay, political asylum is a more general and often interchangeable term, meaning asylum sought or granted for specifically political reasons. Okay, asylum sought for political reasons is political asylum and applies to individuals escaping persecution for their political opinions. Those escaping persecution for political opinions or activities is political asylum. Okay, political asylum is given to these people. It can encompass both territorial asylum and diplomatic asylum. Okay, legal instruments and principles. There are some notable instruments and principles uh, that encapsulate the concept of asylum. First is UDHR, which is Universal Declaration of Human Rights, Article 14. Everyone has the right to seek and enjoy in other countries asylum from persecution. While a declaration, while a declaration, it indicates a universal acknowledgement of the right to seek asylum. So that is UDHR. Next is 1951 Refugee Convention and 1967 Protocol. This is the backbone of international protection of refugees. It provides a definition of refugees and indicates the obligations in respect of refugees, particularly the principle of non-refoulement, which is given in Refugee Convention. This is considered as a just cogence norm. This principle of non-refoulement is a just cogence norm by many, whereby a state is prohibited from expelling or returning a refugee in any manner whatsoever to the frontiers of the territories where his life or his freedom would be threatened by reason of persecution. Okay, so this is called as the principle of non-refoulement. So state cannot return a refugee to that particular territory where his life will be threatened. Okay, so that is the principle of non-refoulement. So this is a just cogence norm. These are the legal principles. UDHR okati, Refugee Convention, and principle of non-refoulement. Then relevant case laws. Asylum case again. This uh, Colombia versus Peru. Colombia granted diplomatic asylum to Peruvian political leader Haya de la Torre in its embassy in Lima and requested safe conduct for him. Peru said no, alleging an abuse of diplomatic asylum. The key point here is ICJ held that there is no general legal obligation for a state to grant diplomatic asylum or to grant safe conduct for asylum seeker from the embassy. Such a right must derive from either a binding treaty or a specifically established and consistently following custom in a region. The court made clear that diplomatic asylum is an exception to the territorial sovereignty of the states, which cannot be invoked unilaterally. This case clearly defined the limited form of diplomatic asylum under general international law. Colombia versus Peru. Next is Julian Assange case, UK, Ecuador, 2012-2019. Facts is Julian Assange was being pursued for extradition to Sweden, later to US. Ecuador granted him diplomatic asylum in its London embassy. After 7 years in the Ecuadorian embassy, the UK refused to allow him safe conduct out of the country, citing its territorial sovereignty and its decision not to grant him legal safe conduct. After Ecuador withdrew its diplomatic asylum, he was arrested by the UK authorities. So, the key point here is this real world example illustrates well the legal and political tensions surrounding the idea of asylum and the fact that there was not a universal rule granting Assange a safe conduct. Importantly, it demonstrates that humanitarian politics of the state granting asylum, that is Ecuador, conflict with the sovereignty and legal process of the territorial state, that is UK. So there is a conflict here. That is what they are talking.
So in this case, it is very interesting. So the just cogence has gone with the wind here. I mean that rule of just cogence, right?
Principle of non-refoulement.
Yeah, it's no longer applicable in this case. It's just a power play. Okay, anyway, just curious. Sorry.
Okay. Contemporary insufficiencies and challenges. So asylum remains vital in an unstable world. It provides an essential protection mechanism for whistleblowers, journalists, political dissidents. Think of Edward Snowden's asylum in Russia. However, there are significant challenges. It is vital. We need protection for whistleblowers, journalists, political dissidents, but there are so many challenges, including national security. More and more states are now invoking national security or counter-terrorism to deny asylum or grant protection without regard to humanitarian need for protecting for protection, creating a tension. Displacement is today increased crisis, that is Syria, Afghanistan, Ukraine, Sudan, and the level of forced displacement has created the highest ever number of displaced people whole populations. This has affected the already strained asylum process and incapacity of even states with adequate policies to adapt to unplanned people movement in numbers. So displacement is another problem that is hindering this asylum helping and all that. Okay, and extraterritorial Assange's case demonstrates that some ongoing discussions related to extraterritorial asylum has its limits. Okay, and its limits. Okay, climate change, climate related migration is a new challenge. Climate related migration is another new challenge to a traditional definition of refugee and to the scope of asylum. So, conclusion here is asylum remains a critical humanitarian mechanism that provides a fine balance between sovereign right of the states to grant protection and the underlying human right principles. While territorial asylum is understood, accepted, and there is a robust refugee law that is currently enforcing, diplomatic asylum has no universal legal basis, as demonstrated clearly by the asylum case. The current practice tends towards complex legal political outcomes, showing a great increase in tension between the prerogatives of the states and obligations of international responsiveness in the face of continuing domestic persecution, migration, pursuit of justice. Everywhere there are challenges, complexities. That's what is given. Conclusion.
Correct.
So legal instruments are this UDHR, all this. Subtypes are, we should remember subtypes: territorial, diplomatic, and political asylum. Legal instruments are UDHR, Refugee Convention, Principle of Non-Refoulement, which is a just cogence norm. Relevant case laws are asylum case and this recent Julian Assange case. So even though it is important for these certain sections of people like whistleblowers, journalists, all this, there are so many challenges many challenges are there: displacement, migration, national security, all this. That's Anybody wants to add?
No, I think it's okay.
Okay, I'll read this
Are
also.
people
Diplomat.
there? Why is it very quiet? Okay.
Shall I continue, Venu Garu?
Yeah, continue. I'm sorry, I was eating dinner. I'm listening. I'm listening. Yeah.
Yeah. Okay, no problem. Okay, I'll go with the 15th one also. After that, somebody can read. If yeah. So 15th is diplomatic envoys, diplomatic immunity. Two times it was repeated. 2023 August and 22 May. Okay. So diplomatic immunity. What is this under? It is a concept of international law that recognizes certain privileges and immunities for the diplomatic agents and their missions in the host state. So, the primary function of diplomatic immunity is not only to assist in the efficient performance of the functions of diplomats. 1 minute, just one. Yeah, sorry. So, diplomatic immunity is a concept of international law that recognizes certain privileges and basically certain privileges and immunities are given to this diplomatic agents. Okay, so what is the primary function of this diplomatic immunity is not only to assist in efficient performance of the function of the diplomats but also to protect them from harassment, coercion or intimidation by the host state, often described as a functional necessity, and to allow them to effectively communicate and represent their sending states based on their own terms. Basically, efficient performance of function of diplomats and protect them from harassment and coercion and intimidation by the host state. So, diplomatic immunity typically covers the diplomat's person, the premises of the diplomatic mission, official communications, and the property, and is based on traditional codified treaty law and customary international law. So, it covers the person, the premises, the official communication, the property. So, all this codified treaty law and customary is based on, okay, fine. So that is covered in diplomatic immunity. Framework is Vienna Convention on Diplomatic Relations, VCDR 1961. So it is the most widely ratified and universally accepted guideline for the uh, conduct of diplomatic and consular relations. It codifies settled customary international law on this topic. So basically, this is the framework. Legal framework is this Vienna Convention on Diplomatic Relations, 1961, VCDR. Okay. So some salient features are as follows. First is the personal inviolability of the diplomatic agent, Article 29. So the person of a diplomatic agent is inviolable. They cannot be arrested or detained. The host state must treat them with respect, okay, and take all appropriate steps to prevent the attacks on their person, the freedom or the dignity, okay. And so that is a person is inviolable. Article 29 according to this VCDR. 31 of VCDR ante immunity from jurisdiction. The diplomatic agent has immunity from criminal jurisdiction of the host state, and except in a few situations, for example, in cases of private immovable property or other professional commercial activity outside the performance of the agent's official duties, immunity from and also immunity from civil and administrative jurisdiction. So exceptions are this, but apart from that, they have immunity from criminal jurisdiction, civil and administrative jurisdiction, according to Article 31 of VCDR. So Article 22, premises, inviolability of the mission premises. Host state agents may not enter them without the consent of the head of the mission. Okay, so premises of the diplomatic mission are also inviolable. They are immune from search. requisition, attachment, or execution. Okay. Next is 32, waiver of immunity. Waiver of jurisdictional immunity will only occur with respect to the sending state and not the diplomat. The waiver must be express. Okay. And next is 41, duty to respect the laws of the host state. Christians and missionaries, notwithstanding, diplomats, irrespective of their levels of immunity, bear the fundamental duty to respect the laws and regulations of the host state and not to interfere with the internal affairs of the host state. Immunity does not mean impunity. Okay. Immunity does not mean impunity. So just respect the laws of the host state. That is 41. Article 91 is persona non grata. The host state may declare any diplomat persona non grata, requiring their recall or expulsion without any explanation. So, this is Article 9. These rules are understood to reflect the customary international law, which is applicable irrespective of state adherence to the VCDR. So, these are the 1, 2, 3, 4, 5, 6 salient features of VCDR, which is Vienna Convention on Diplomatic Relations, 1961. This is given in the diplomatic immunity. Okay. Next is scope. Scope of immunity. Scope of immunity is full immunity, limited immunity, limited immunity again for service staff, then mission premises. So the VCDR outlines the scope of immunity with regard to the type of diplomatic agent. So first is full immunity. Diplomatic agents, heads of the mission, diplomatic staff, which include consular secretaries, all of them they enjoy full immunity from criminal, civil, administrative jurisdiction for all the acts, official, private. Okay, so this immunity extends to the members of their families who form a part of their household, not only to them, to the members of their families also. Okay, they are granted full immunity. Next is limited immunity, administrative and technical staff. This class of staff include the administrative officers, secretaries. They enjoy immunity from jurisdiction only for the acts performed in the course of their official duties. Only for the acts performed in the course of their official duties, they have immunity. They enjoy that. Limited immunity for the service staff. Staff in domestic service of the mission, including drivers, cleaners, they have immunity only for the acts performed in their official capacity. Same thing for both. Okay, mission premises, the embassy, chancellery, and surrounding land are inviolable as they are functional extension of the sending state's sovereignty. Inviolable. Okay. That is, yeah, inviolable. Okay. So this is the scope of immunity. Full, limited, and mission premises also has the immunity. And relevant case laws. Oh, this is a famous case, I think. Devyani. United States versus Devyani Khobragade, 2013 US District Court. So Devyani K was an Indian Deputy Consul General of in New York who was arrested and indicted, I think, indicted, okay, whatever, indicted for visa fraud related to her domestic workers' employment. So India claimed that they enjoyed full diplomatic immunity under the VCDR. So the key point here is the case raised complicated issues regarding immunity for certain diplomats, the difference between consular officers and diplomatic agents, as well as the interpretation of VCDR provisions regarding the date of the alleged offense versus the date of arrest. Most notably, it led to a major diplomatic standoff and outlined how political sensitivities and bilateral tensions can increase when host states attempt to enforce domestic laws. This is Devyani K versus United States. The persona non grata, Zaire versus Belgium practice diplomatic sanctions. So the facts are there was several examples, including Zaire's placing of a Belgian diplomat as a persona non grata status with no explanation. So the key point here is Article 9 of VCDR. 990, they can just recall or ex expel without any explanation. Okay. So key point is under Article 9 of ECDR, a host state may declare any diplomatic agent persona non grata at any time. They need not explain their decision, and creating an obligation on the sending state to recall or terminate the functions of that person. If the sending state does not agree, the host state may refuse to recognize them as a member of the mission. So, this provides a mechanism for the host states to manage serious misconduct or greater bilateral tensions without impinging or infringing on the inviolability of the diplomat, which provides a means to respond to possible serious abuses of immunities, whereby immunity does not equate to impunity. Okay, current challenges and trends. Diplomatic immunity has certain challenges. It's facing continuing challenges. Current challenges of what? Abuse of the immunity. High profile public cases of diplomats allegedly committing serious offenses, example, trafficking in persons, domestic violence, and deaths from drunk driving. So, there have been movements uh, to remove the immunity due to public outcry from domestic laws being enforced. That is abuse of immunity. There's a challenge balancing sovereignty. Host states, they are constantly faced with managing their sovereign right to enforce the domestic law with their international obligations to respect the immunity. Okay, then accountability for diplomatic agents. There is increasing pressure on sending states to waive immunity for their offending diplomats, or in the alternative, and ensure that their diplomats are prosecuted or subject to disciplinary process upon returning home. Accountability for the diplomatic agents. Okay. Then digital diplomacy. The new age of cyber related activities and online settlement of disputes has taken the traditional definitions of much of the above into new and uncharted waters. So that is again a challenge. Conclusion is diplomatic immunity is one of the most important principles in the conduct of peaceful and effective international relations, protects the diplomats from coercion of the host state, and ensures functional independence of the diplomat. Despite not being without any controversy as a result of potential abuse, the VCDR creates a solid baseline to maintain the dignity for all, and at the same time giving means to respond to misconduct, including mechanism of waiver, declaring persona non grata, and prosecution by the sending state. In sum, this system of privileges and immunities is essential for continuing the core principles of mutual respect, sovereign equality that are underpinned at the heart of diplomacy. Anybody wants to add?
Yeah, thank you, Hemali, for reading 5 questions. A continuous stretch.
I didn't realize
She
it
read
fast.
6. In fact.
6.
Yeah, and super fast గా అయిపోయింది మేడం.
I hope something got into her head. That is more
Yes,
important.
definitely. Yeah. 5 questions. మనం 2 hours కి 5 questions తీసుకున్నాము. ఇప్పుడు మీరు 1.5 hour లో you save 30 minutes. I think we can complete 2 more minimum.
We can complete 5 more.
ఎందుకు మొత్తం
Madam,
బుక్ కంప్లీట్
20
చేసేద్దాం.
దాకా చదువుదాం.
బుక్ కంప్లీట్ చేసేద్దాం
20
మేడం.
దాకా చదువుదాం. Yeah, why I'm saying is next the ICC, which is pretty straightforward. Veto, straightforward. Ex equi et bono, straightforward. Moon treaty, straightforward.
Ma'am,
Plebiscite,
all
straightforward.
these are not straightforward to us, madam.
ఏ కాదులే ఒకసారి చదివితే అర్థం అవుతుందని మీరే చెప్పారు
We
కదా
are
ఇందాక.
focusing on quality, madam, not quantity.
సరే అయితే
So, 5 కష్టం మేడం, హాఫ్ అన్ అవర్ లో ఎలా చేస్తాం?
హాఫ్ అన్ అవర్ ఏనా ఇంకా? ఓకే ఓకే, ఐ థాట్ 1 hour ఉందని. ఓకే సరే,
ఓకే,
ఓకే
మీరు 16 మీరు రీడ్ చేయండి. బాగానే ఉంది మీ సిగ్నల్.
ఓకే.
ఇంకా మన డేట్స్ రాలేదు కదా? డేట్స్
రాలేదమ్మా, రాలేదు.
It will come as a very awkward surprise. That's my fear.
I think exams will be there in October.
No, 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 Emily.
God, what a
Exams will be
wishful
there.
thinking.
No,
Exams
it
will
Let,
be
will be
there.
let's be
Lerama,
prepared
exams
for
will be
15th.
there either
from
15th or
15th.
22nd.
22nd, there'll be holidays. అని
No,
అంటున్నారు.
holidays for everybody, but not for us, కదా. మనకి సో లాస్ట్ టైం కూడా హాలిడేస్ లోనే సమ్మర్ హాలిడేస్ లో ఎగ్జామ్ పెట్టలా. సో
22nd నుంచి start అయితే we will get lot of nice gaps between one exam and the other because of some festivals and all. అట్లా వస్తే బాగుంటుంది 22nd నుంచి అయితే అట్లీస్ట్
they will finish
మధ్యలో
it
గ్యాప్.
before Dasara, which is October 2nd.
How will they finish 22nd వస్తే?
22nd వస్తే అయిపోతుంది మేడం. 22nd,
ఎట్లా
24th,
మధ్యలో
26th.
సండేస్ ఉన్నాయిగా.
అవును 22nd, 24th, 26th. ఇంకా
29th October 1st.
29th, then 1st. అంతే.
Second is festival. మీరు హ్యాపీయే కదా.
యాడ్ అయిపోయాను.
కానీ నాకు ఎందుకో అక్టోబర్ లో
Okay.
అవుతుంది అనిపిస్తుంది. ఓకే ఫైన్.
I really hope it's true. Anyway, International Criminal Court. We are talking about the functions, composition, and jurisdiction. International Criminal Court is the world's first permanent treaty-based international court. So it's a permanent treaty-based international court. It came out of a treaty between different nations, whose role is to prosecute individuals, not states, but individuals, for crimes of international concern and constitute the most serious crimes of concern to the international community. Basically, it's come out of a treaty between different states. It prosecutes individuals for crimes of international concern. What are those crimes? Genocide, crimes against humanity, war crimes, and the crimes of aggression. These are the 4 different types of crimes for which individuals can get prosecuted in ICC. ICC signifies a significant turning point in international law, moving from state accountability to individual criminal responsibility. So from state accountability to individual criminal responsibility. The ICC operates separately from the United Nations, exists as a complement to the national jurisdictions, and only intervenes if states are truly unwilling or unable to prosecute these significant crimes of international concern. If the individual states are unable or unwilling to prosecute, then the ICC will come into the picture, and then it will start prosecuting them. So they will first give importance to the national jurisdiction, but if that doesn't give the justice, then ICC steps into the picture. What is the legal basis? Legal basis is the Rome Statute in 1998, which led to the creation of ICC. Establishes the court formally adopted on 17 July 1998 and came into force in 2002. Article 1 establishes the ICC, the permanent institution with jurisdiction over individuals committing serious international crimes. Next, Article 5 publishes the core subject matter of court's jurisdiction on the 4 principal international crimes. 4 principal international crimes, చదివాం కదా ఇందాక, genocide, crimes against humanity, war crimes, and crimes of aggression. So Article 5 talks about the subject matter, which are these 4 principles, 4 crimes. Then Article 17 publishes the principle of complementarity, declaring that the court will not exercise its jurisdiction unless the state genuinely fails to investigate to prosecute serious international crimes, which respects the primacy of national sovereignty but provides a critical backup for impunity. So if the states don't act, then the ICC will jump into the picture. This legal basis, Article 1, Article 5, and Article 17. Next, what is the composition of the court? It basically is made up of 4 different types, 4 organs. One is the presidency. This organ manages the court overall as well as the relationship between the court and the external world. So it is the management of the court, and then its relation with the external world is done by the presidency. Then the next limb is judicial divisions. This organ comprises elected judges to the ICC. So it has elected judges to the ICC within the pre-trial chamber, trial chamber, and appeals chamber. This organ is responsible for judicial functions of the court. So all judicial functions of the court, judicial divisions are responsible. and they comprise elected judges, chambers, pre-trial chamber, trial chamber, and appeals chamber. Office of the prosecutor. This organ is mandated by the Rome Statute to conduct investigations of certain crimes and provide criminal prosecution. Then registry. This organ provides the administrative and operational function of the court as a whole. So this is basically to do with administration and operational management. As of 2024, the ICC has 123 state parties, meaning 123 states are parties to the agreement of ICC. However, several major world powers such as United States, China, India, and Russia remain non-parties to the court, which hampers the court's universal reach or ability to enforce decisions, which is interesting. I did not know this. So US, China, India, and Russia remain non-parties to this court. So that is a challenge actually. Then, what is the jurisdiction of ICC? The jurisdiction of ICC is ఇందాక అనుకున్నాం కదా subject matter which is mentioned in Article 5, the 4 crimes: genocide, crimes against humanity, war crimes, crimes of aggression. What is genocide? Acts committed with an intent to destroy in whole or in part. This is nothing like, it's like ethnic cleansing కదా, నేషనల్ ఎథ్నిక్ రేషియల్ ఆర్ రిలీజియస్ గ్రూప్ ని మీద క్రైమ్ చేయడం, కిల్లింగ్ దెమ్ బేసికలీ. That is genocide. Crimes against humanity, widespread or systematic attacks against any civilian population, that is murder, enslavement, torture, rape, which we see happening in parts of Nigeria and all. War crimes, serious breaches of the laws and customs applicable in armed conflict. Those are the war crimes. Then crimes of aggression. This refers to illegal use of force by a state. The crime of aggression was added by the Kampala Amendments adopted in 2010. So these are the 4 things: genocide, crimes against humanity, war crimes, crimes of aggression. This is subject matter of ICC. Next, this is subject matter. Next is territorial and temporal jurisdiction. The ICC has jurisdiction over crimes that are mostly committed during territorial within a state party or carried out by a national of a state party. In relation to this article, ICC is limited to jurisdiction over crimes after the passage of July 1st, 2002. So there is limitation to territorial and temporal jurisdiction over crimes that are mostly committed during territorial within a state party or carried out by a national of a state party. This I don't know. We can discuss after I finish reading. I'm still not clear on this territorial and temporal jurisdiction. Next thing is referral methods. Article 13. Cases may be referred to the ICC by a state party, meaning any state. A prosecutor can initiate an investigation proprio moto, meaning suo moto anukunta. Prosecutor can initiate an investigation proprio moto through this, though this requires permission from the pre-trial chamber. So the prosecutor can suo moto start an investigation. Then the third method, referral method, is the United Nations Security Council, Article 13b. This last article is notably significant as, in part, it enables the Security Council to refer situations from states that are not parties to the ICC. So even if the states are not part to this International Criminal Court, the United Nations Security Council can still refer those cases to the ICC. So there are 3 referrals. One is a state party, one is a prosecutor can initiate action. The other is referrals from United Nations Security Council. Then there are 2 relevant case laws. Prosecutor versus Thomas Lubunga Dilo. Lubunga was a Congolese warlord that was the first person convicted by the ICC. Wow. For the war crime of enlisting and using child soldiers. In this case, the ICC affirmed individual responsibility for serious international crimes and acknowledged the procedural integrity of ICC, making a significant milestone for international criminal justice. So this is a internal war crime that happened within the country of Congo. The next thing is prosecutor versus Omar al-Bashir. Sudan, ongoing. It's still ongoing. The ICC issued arrest warrants against the president of Sudan, Omar al-Bashir, for genocide and crimes against humanity in Darfur. This case demonstrates the ICC's jurisdictional reach over sitting heads of state. So even they can, sitting heads of states can also be prosecuted. However, this case also illustrates limitations in enforcement and problems related to unwillingness of states to enforce arrest warrants via cooperation, especially in relation to parties that are not parties or otherwise unwilling to cooperate or enforce a warrant. One of the important examples is the ICC has issued an arrest warrant against Benjamin Netanyahu, the sitting Prime Minister of Israel, but nothing is happening anyway. Current challenges and developments. Despite challenges, including some challenges of non-cooperation on behalf of some states, allegations of selective justice. So the ICC also engages in selective justice, especially in relation to the focus on Africa and reliance of states to enforce warrants by providing arrest all of which shows an important weakness, as the ICC does not have any independent means of enforcement. The ICC has many unique features, including, among others, victim participation and victim reparation. Ongoing investigations, Ukraine and Palestine, illustrate ICC's evolving and expanding jurisprudence. The International Criminal Court represents a very important and at times invaluable new player in the global counter-impunity effort to prosecute individuals for the most atrocious examples of crime in the world. Even with ongoing challenges, the ICC contributes to the global accountability movement for the notion that no one is above international law. Adi. Can Venu Garu please explain the territorial and temporal jurisdiction, if you understood quickly in like 1 minute?
Ma'am, I'll try, madam. So, temporal is nothing but basically the jurisdiction date, July 1st, 2002, Tarvata cases తీసుకోగలరు. Okay. And the territorial means they can try crimes that are committed on the territory of the country or by a national. అంటే టెరిటోరియల్ జ్యూరిస్డిక్షన్ యూజువల్ గా ఇప్పుడు ఐపీసీకి ఉంటుంది కదా, బట్ ఇక్కడ ఏమంటున్నారంటే ద ఐసీసీ ఆల్సో హ్యాస్ క్యాన్ ట్రై క్రైమ్స్ కమిటెడ్ ఆన్ ఎ పర్టికులర్ స్టేట్ ఆర్ బై అన్ ఇండివిజువల్ ఆఫ్ దట్ స్టేట్.
ఓకే.
సో టెరిటోరియల్ కూడా ఉంటుంది, ఎందుకంటే ఇప్పుడు మనం ఐపీసీ అంటాం కదా. సో వాళ్ళకి టెరిటోరియల్ జ్యూరిస్డిక్షన్ లేకుండా వాడు మన నేషనల్ ఎలా చేయగలడు అన్నప్పుడు దే డూ హ్యావ్ టెరిటోరియల్ జ్యూరిస్డిక్షన్ అన్నమాట.
ఓకే.
హలో మ్యామ్, మీ
Yeah,
వాయిస్
I'm able to hear you.
No, we can't hear you in
Oh, no?
between.
No, I was not talking at all.
Okay. Okay, we'll go to the next one, madam.
Yeah, I can give one example here. Saddam Hussein trial by America. I don't know whether it comes under territorial or temporal jurisdiction, but they because the crime was happened before 2000 July 1st 2002. They had set up US had set up a even though ICC exists by that time, they could not trial because of this particular rule, and they had set up a separate tribunal and gave verdict for his war crimes.
No, that's a good point, sir. First of all, ఏంటంటే సద్దాం హుసేన్ ఐసీసీలో ట్రై చేయలేదు, లోకల్ ట్రై చేశారు. ఎందుకంటే ఐసీసీ హ్యాడ్ టెంపోరల్ లిమిటేషన్. సో దేర్ క్రైమ్స్ వర్ కమిటెడ్ బిఫోర్ July 1st 2002. సో వాడి యాక్చువల్గా వాడు చేసిన క్రైమ్స్ అన్ని వేర్ కర్డ్స్ మీద కదా, విచ్ వాజ్ 1980s to 1990s. సో స్పెషల్ ట్రిబ్యునల్ కోర్ట్ లాగా పెట్టి మన ఇండియాలో పెడతారు కదా సార్, అలా చేశారు. కానీ ఐసీసీకి జ్యూరిస్డిక్షన్ లేదు, ఎందుకు టెంపరరీ లిమిటేషన్ ఉంది. బట్ ఇట్స్ అ గుడ్ పాయింట్.
Shall I move to the next one?
Yes, madam. Yes.
Veto and double veto. Last, okay.
We'll try. Yeah.
The veto power constitutes a vital, though contentious, aspect of the United Nations Security Council. This power allows any of the permanent members, the P5, China, France, Russia, the United Kingdom, and the United States, to stop the adoption of any substantive resolution, regardless of whether it has majority support. So even if one member of the 5 vetoes, then it stops the substantive resolution. The veto reflects the political realities in power dynamics existing at the time of the United Nations establishment and is meant to balance the efficiency of collective security with the supreme interest of the great powers that won World War II. So there's a tussle between collective security and the supreme interests of the great powers. One distinct variation of veto power is the double veto. A double veto occurs when the permanent members vetoes a substantive resolution and also vetoes the decision of whether a matter is procedural or substantive. So when an issue comes up and when someone says because a veto cannot be exercised against a procedure, it can be only exercised against the substantive resolution. So they will say this is not procedural resolution, this is substantive ani oka veto vestaru. Then that substantive మీద ఇంకో veto exercise చేస్తారు. That is what is double veto. So vetoes a substantive resolution and also vetoes the decision of whether a matter is procedural or substantive. A double veto allows a permanent member to exercise their veto power a second time on an issue by vetoing the substantive resolution and then vetoing the decision to rule on whether the matter was procedural or substantive. The permanent member is doubling the extent of their control over the decision-making process by moving what is otherwise a procedural matter. So even if it is a procedural matter, they can veto and say it is a substantive matter because they can get a veto power on the substantive matter. So by moving what is otherwise a procedural matter into a substantive one, thus allowing for a veto. This is the this is a thing here, quite hypocritical anyway. Legal framework, United Charter, UN Charter articles. What is the legal framework? The veto power is codified in Article 27 of the United Nations Charter. So veto power is under Article 27. 27.1, what does it say? States that each member of the Security Council shall have one vote. Adi 27.1. 27.2. Decisions of the Security Council on procedural matters shall be made by an affirmative vote of 9 members, provided that no negative vote is cast by any of the permanent members. So each decisions of Security Council on procedural matters shall be decided where no negative vote by any of the permanent members and affirmative vote of 9 members. Article 27.3. Decisions of the Security Council on substantive matters shall be made by an affirmative vote of 9 members, including the concurring votes of permanent members. The concurring vote is the basis of the veto. So that is all the permanent members have to concur for the substantive matter to pass. The abstention is absence. Abstention by a P5 member is usually not seen as a veto. So just by not being present there doesn't constitute a veto. The Charter delineates procedural matters from substantive matters so as to restrain the veto, and the double veto exploits the vagueness of whether an issue is procedural or substantive. So this is about the double veto and the legal framework. Substantive and procedural matters and the double veto. Substantive matters. These deal with a decision about a tangible action, such as imposing a sanction, authorizing a peacekeeping operation, establishing a tribunal, or authorizing the use of force, such as actions under Chapter 7. In these cases, the P5 must reach consensus and vetoing is permitted. So even substantive matters, sanction, imposition of sanctions, peacekeeping operations, establishing tribunal, these are substantive matters. So their veto power is permitted. Then procedural matters. These relate to the internal procedure of the council, such as adopting the agenda, inviting non-permanent members, or when to meet. Even procedural matters, operational matters. The P5 do not need to reach consensus about procedural matters, and vetoes are rarely applied. So a double veto occurs when a P5 is asked to vote on a particular proposal which is procedural. So when the P5 is asked to vote on a procedural matter and they argue that the issue is substantive, when they say no, this is substantive, this act of dissent creates a substantive vote. If the P5 member votes no, they effectively use the first veto against a procedural vote and now is deemed substantive. So now it becomes substantive. If that same action were deemed substantive, it could then vote on the substantive resolution and utilize its second veto. So in the substantive thing, it can, if it doesn't like it, it's going to use the second veto. The double veto gives the P5 member enormous influence over both the agenda and definitions of the action. So both the agenda and definitions of the action, they get a lot of power. So this is about that. And what are the relevant case laws? Admission of a state to the United Nations. So that USSR vetoed in 1947. The point, in the debates early in the United Nations existence concerning applications for membership, the USSR used its veto decisively to block applications for admission of several states. When it was suggested that the question of admission was a procedural matter, the USSR declared that the question of whether the matter was procedural or substantive was a substantive issue that was also subject to the veto. This asserted the existence of double veto doctrine and gave incredible authority to the P5 to control the Council's agenda and action by not allowing any item to be designated as procedural. So pretty much there is nothing procedural. Everything has become substantive. Korean question, United Nations Security Council 1950. Veto absent procedural workaround. What is the point? When the Soviet Union was boycotting meetings of the United Nations Security Council, the Security Council adopted resolutions holding multiple interventions in Korea. Notably, since neither absence nor abstention counts as a veto in a P5 member, as determined by ICJ in the Namibia advisory opinion, and the United Nations Security Council was issuing resolutions that formatted the interrogation as procedural, or by proceeding in the absence of a negative vote, the UNSC was able to proceed without the approval of USSR. Basically, USSR was abstaining from all this, and the United Nations were able to proceed without them. This was illuminating because it demonstrated the key limitation of a veto. A P5 member must be present and cast a negative vote in order for a veto to occur. He cannot just abstain. So abstinence is not veto. So contemporary issues and reform debate. Veto power continues to create considerable controversy and prevent the United Nations Security Council from acting when it is needed most, that in the cases of Syria, Ukraine, and Palestine. It is the means by which national interests frequently surpass collective international peace and security. So national interests are always overriding than the collective international peace and security. Gaps in legitimacy for the United Nations stem from this problem. So in the call for UNSC Security Council reform, suggestions have included. So these are the suggestions that were given to reform United Nations Security Council. One is eliminate or limit the veto power, especially in terms of mass atrocities. France's Mexican proposal. I don't know what the proposal is, but anyway, eliminate or limit the veto power is one suggestion that is being made. The other suggestion is expand UNSC membership. This has been a long-standing demand by including new permanent members of the United Nations Security Council, lessening the monopoly of the P5. A recent development for reform included United Nations General Assembly Resolution 76 by 262 in 2022, which indicated that P5 members can continue to exercise their veto power, but must justify their veto to the General Assembly in a public forum. So earlier they don't have to justify their veto, now they have to justify to the General Assembly of the United Nations. This resolution is seen as a first step towards holding the P5 accountable. What is the conclusion? The conclusion is the veto and double veto provide the P5 with inordinate power over the decision-making process for the globe. In particular, though the decision-making process yet deny the global body of clear decision-making authority. I don't know. While they are legally found in Chapter 5 of the United Nations Charter, they remain a politically burdensome burden that complicates the idealism versus realism debates in international relations. The ongoing debate over reform to the veto will continue to test the United Nations' relevance and fairness in current multipolar world. This is veto power. I hope things are clear. And if you guys are done, then we will close. Otherwise, we can read one more. It's up to you guys. No force. Hello, people are sleeping.
I am done, madam. I am already sleeping.
Okay, done. Okay, no problem.
Okay. Tomorrow
Yeah.
we'll see whether we'll do with part C, and maybe people can just read the rest on their own, part A.
Yeah. Sounds
Or
good.
shall we do some more?
We'll
I'm
do
okay
up to
with either
20,
way.
sir.
Huh?
Up to 20 chesi, and
20
3
till
more
20 will
chesi,
Okay, done.
then we'll move to
Okay.
part
Because
C.
అందులో అంటే 2 times రిపీట్ అయినవి కూడా ఉన్నాయి కదా. సో బెటర్ టు
ఆల్మోస్ట్ ఇందులో కూడా చాలా రిపీట్స్ వచ్చినాయి సార్. ఇప్పుడు ఈ వీటో కానీ ఐసీసీ
అవును. ఎగ్జామ్ లో రిపీట్ అయినాయి అంటున్నా.
ఐసీ ఓకే ఓకే ఎగ్జామ్
వీటో వాజ్ రిపీటెడ్ ట్వైస్. ఇక్కడ నుంచి అన్ని సింగిల్ టైమ్స్ వచ్చాయి.
నెక్స్ట్ సింగిల్ అంతే. రైట్. ఐ థింక్ వీ కెన్ స్టాప్ హియర్ అండ్ గో ఫర్ పార్ట్ సి. రైట్ సార్.
Yeah.
యువర్ పాయింట్ ఇస్ రైట్.
Okay.
Okay. We are
Okay.
using data science to make decisions. ఓకేనండి సార్. టుమారో విల్ డిసైడ్ అండి సార్. పార్ట్ సి అంటే చాలా మంది వస్తారు, అందుకని మెసేజ్ పెడతాను మరి.
విల్ స్టార్ట్ విత్ పార్ట్ సి సార్. ఎందుకంటే ఇవన్నీ రిపీట్స్ లేవు కదా.
కానీ part
మళ్ళీ
C ఒకసారి
మనకి ఎగ్జామ్ అక్టోబర్ లో అంటే మళ్ళీ ఇవన్నీ
Examination.
ఓకే సార్.
లేదు నో కన్ఫ్యూజన్ సార్. లెట్స్ అజ్యూమ్ ఇట్ ఇస్ 15th ఓన్లీ.
ఓకే.
లెట్స్ కంప్లీట్. యా.
ఓకే సార్, డన్.
బీ రెడీ ఫర్ దట్.
యా. ఓకే సార్ అయితే.
ఓకే.
Bye.
Okay, thank you.
థ్యాంక్స్, బై.